appearances are Mr. Lang appears in person with his counsel, Christopher Gramstrup, in person. We have the state appearing through District Attorney Kevin Schmidt. We're set today in this matter for a plea and sentencing, and that is proceeding as such, correct, Mr. Gramstrup?
Yes, Your Honor.
And I do have a plea questionnaire waiver of rights form in front of me. Mr. Lang, do you recognize this document?
Yes.
And did you sign this document? Yes. Mr. Gramstrup, can you please recite the agreement for the record?
Your Honor, Mr. Lang would be pleading guilty to count 1. Count 2 would be dismissed outright. There's a joint recommendation on count 1 for 1 year probation, 4 months county jail as a condition imposed and stayed. No sentence credit due.
Mr. Lang, you indicated that your attorney went over this document with you, go over it thoroughly.
Yes.
Did he essentially go over it word for word?
Yes.
And do you understand everything on this document?
Yes.
It states that you're going to plead guilty to 1 count of violation of an injunction restraining order. You're 59 years old, you have 10 years of schooling, you can read, write, and you understand the English language. Is that correct?
Correct.
You're not receiving treatment for mental illness or disorder, no alcohol, drugs, or medication.
No.
Do you understand that upon conviction, you face a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
You also understand that there is a recommendation, a joint global offer that you've reached, where there would be a recommendation to the court for 1 year of probation with an imposed and stayed sentence of 4 months in jail. Do you understand what that means?
Yes.
Do you understand that I'm not bound to follow that recommendation?
Correct.
If I thought, based upon the facts, that it was more aggravated or that you deserved or should get a harsher punishment, do you understand I could sentence you to the maximum penalty?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Mr. Gramstrup, did you thoroughly go over the facts that are alleged in the criminal complaint with Mr. Lang?
I have, Your Honor.
And do you believe he understands those facts and what the state would need to prove the elements of the charge?
I'm quite confident that he does.
May the court use the probable cause section of the criminal complaint to find a factual basis?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No.
As to count 1, violating a harassment restraining order injunction, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed outright. A judgment of conviction will be entered today. We do have victim who is present here. Does victim wish to make a statement? All right, the victim can come up to this black little desk and you can either state your name or your initials, whatever you feel the most comfortable, and provide your statement.
I write this with the burden not only of my own experience, but out of the accumulated fear, anxiety, and harm carried by others who've had the misfortune.
So let's break that down. Scott Lang is getting 1 year of probation with 4 months in county jail, but wait, it's imposed and stayed. That means unless he messes up again, he likely won't even serve that time. Basically, behave, and you're free. But given his history, that's a big if. What do you think? Is that fair justice or just another slap on the wrist?
Of encountering Scott Arlen Lang. What I detail here is not theoretical. It's a chilling and relentless pattern that stretches across nearly 4 decades. I ask the court not to consider this man in isolation, but in the context of his life's choices, a legacy of violence, threats, manipulation, and a brazen disregard for the law. Let me begin with this. Scott Lang is not rehabilitated. He is not misunderstood. He is dangerous. His criminal history isn't abstract. It's a 23-page document that I have with me today of convictions of court filings that include, but are not limited to, second-degree murder, felony strangulation, felony domestic violence, assault on a peace officer, possession, fleeing police, multiple counts of violating no contact orders, criminal damage to property, harassment, and disorderly conduct. Repeatedly, In almost every instance, the response was probation or supervision, which he's violated more than a dozen times. Statistically, the risk associated with this level of criminal history is staggering. A study by the U.S. Sentencing Commission found that individuals with more than 7 prior convictions have a 61% likelihood of reoffending. Scott Lane's record exceeds that threshold by a wide margin. He is not a former offender. He is a persistent, ongoing one. The violation in front of the courts today was not a one-time incident, but rather just one more chapter in Scott's long, escalating pattern of violence. A previous prosecutor had stated on Scott's past charges, they reflected ongoing themes of violence, confrontation, and paranoia. On April 12th of 2018, the state on record stated that they recognized these as persistent patterns, and they are still present today. On June 26, 2025, in yet another courtroom, in yet another criminal case involving violence and confrontation. While previously incarcerated, Scott had been removed from a jail treatment program for physically assaulting another inmate, further demonstrating his inability to manage aggression, even in a controlled environment. He has repeatedly told others he is a target on his back and that the was in the past, as if that absolves him. But when angry, his instinct is to weaponize his past. And he said to me directly, "Do you know who I am? Do you know what I did?" A chilling reminder that he uses his violent history as a tool of intimidation. Scott is on body cam stating, "I am starting a plan. I ain't playing this game with her. She's going to be dealt with. I have connections. She is the most worthless I've ever known. Let her know I'm done, and I'm going to make plans if she doesn't get out of my life. I'm getting out of here because I don't want anything bad to happen, because I know what's going on in my brain. I'm going to study the house, and I'm going to make some inquiries. You think 30 years in prison, being with PBMs, Hell's Angels, I don't know, connections? She should be smart and move out of here." Scott has bragged about Deputy Michael Moreau, not only to me, but in other criminal cases where he threatened a Menards employee, stating he had a cop and that people should be careful around him. These are not the words of someone seeking redemption.
Whoa. Let's pause. A 23-page rap sheet? Multiple felony charges, strangulation, assault, fleeing, threats, and somehow, it's mostly probation and supervision? That's the justice system on repeat mode. And get this, the U.S. Sentencing Commission says people with 7+ priors are 61% likely to reoffend. Scott? He's way past that threshold. So why is he still getting leniency?
They are the boasts of someone who sees past crimes as leverage. While these cases may not be the direct subject of today's hearing, they remain highly relevant to his behavior and his mindset, which continue to demonstrate he is unrehabilitated and is incapable of becoming a productive member of society. Scott is admitted to drinking and using substances. Scott has used alleged substance abuse to justify previous convictions. His paranoia is well documented in decades of police reports and court transcripts. He will frequently claim people are out to get him or that he's being targeted. He's, again, even claimed to have connections to people, a statement that should raise immediate concern for anybody who's tasked with protecting the public safety, anyone who represents the courts that's sitting in this courtroom today. Violating probation is not just a minor slip. According to research published in Criminal Justice and Behavior, each infraction during probation increases the chance of reoffending by 700%. Scott's repeated violations, including substance abuse, no contact violations, and threats, they are not technicalities, they are predictors of future behavior. In a Minnesota court transcript, a jail call is referenced in which Scott contacted the very wife he claims to love who's sitting in this courtroom today. Immediately after a Danko was dismissed, Scott asked Roxy to put her son on the phone and said, "Apparently there's some problems at home." He insinuated his stepson would be assaulted, implying retaliation or violence was imminent upon his release. He called Roxy again on another number, referring to her son as the spawn of Satan, and continued to berate her. All of my problems started when I met you. You're so messed up you could ruin a dream. This is not love. This is coercion, manipulation, and control. Again, consistent themes in Scott's behavior. If Scott is willing to treat the people he loves this way and states on body cam, I might only have 6 months or a year. I'm trying to make as much money for my wife. I'm trying to set up my wife the best I can. What is he capable of doing to someone who he has no feelings or relationship for? Someone he does not love or care about? In 2024, in this very courtroom, in front of you, Your Honor, I was issued a 4-year injunction against Scott and Roxy Lane. During this time, Scott had retaliated by making false allegations and filing a false restraining order against me. Scott was aware of the restrictions this injunction ordered. However, despite that injunction clearly prohibiting contact, he committed 2 new violations on July 8th and September 26th, resulting in why we are here today. On July 8th, he fired explosives, also known as fireworks, at my home and vehicle, striking my home and my car. When it hit my home, it was loud enough for my children and I that we thought bullets had came through our home. My children were terrified. Scott had admitted to being intoxicated and told officers he was done playing and had connections and was going to go out with a bang. He said he was starting to plan and that I, Marissa, was going to be dealt with. These are not idle threats. They're the words of a man who's already strangled his wife and physically abused not only his daughter, but his stepchild. On September 26th, he and Roxy Lane drove into a restricted area in direct violation of the injunction. Both parties were subject to active court orders. I again provided video evidence to law enforcement. This was not a misunderstanding. It was a calculated act of intimidation. What Scott and Roxy fail to realize is that my home is equipped with a professionally monitored surveillance system. A security company provides 24/7 active monitoring, always recording and reviewing footage. Even when I'm not home, I have full remote access that I can monitor every angle of my property, the front, the back, the sides of the house, the garage, the parking lot, across the street, and even the surrounding fields. In addition, there's multiple trail cameras throughout the fields for added coverage. There is no uncertainty that Scott was caught. The footage is clear. This is not a matter of opinion or debate. He may have attempted to claim it was his brother, Gary, but that argument does not hold. As our family has known both individuals, we know what Gary looks like. We've seen him at Scott's residence. Furthermore, Gary has a criminal record with an official mugshot, making it unmistakably clear that they are not the same. Attempting to confuse or deflect responsibility in this way is just another manipulation tactic, and one that fails in the face of documented evidence. Even with my restraining orders in place, Scott has continued to stalk me. He's entered my driveway, harassed family and friends, used his wife to deliver a 20-page handwritten letter defending his actions and accusing me and my church of worshiping the devil in the basement. This is just not harassment. It is now psychological warfare. Law enforcement has been called to Scott's residence other times within the past year for incidents involving domestics and violence towards others that I've witnessed Burnett County Sheriff's Department at his home for calls that I did not initiate. On several occasions, Roxy had also reached out to me in fear, admitting that Scott was back on methamphetamine, asking for help to get him out of the house. She had specifically requested resources from me, knowing I was working in the capacity of a legal advocate in the court system, further underscoring the seriousness of her situation and the danger she felt. Scott had moved to this town with the intention of hiding his past, but when someone, not me, uncovered it and the community began to learn the truth, he spiraled. Instead of seeking redemption, he chose retaliation. Scott alleges we were friends until I heard 35 years ago he caught. What Scott fails to mention is I discussed this at great length with Scott and Roxy, and I informed him I in no way supported his past choices. However, I can recognize he served his time and had not harmed myself or my children. He also fails to mention he and his wife had brought us over a handmade cake, snacks, and a handmade holiday card after this exchange, as we had put this behind us in an attempt to move forward. Many people ask why this betrayal cuts especially deep for me. It's because I've spent my career working in reentry services, helping formerly incarcerated individuals reintegrate into society with dignity and respect. I've also worked on the other end of victim advocacy, helping survivors find their voice. I firmly believe in second chances, and I firmly believe in rehabilitation. Had Scott shown a shred of respect for me, my family, or this community, I would have been probably among the few willing people to stand behind him and offer him that chance to prove redemption. But he didn't. He weaponized my compassion. He used proximity and legal loopholes to terrorize me. Multiple other district attorneys' offices, time and time again, have failed to protect the many victims who have suffered under Scott's ongoing reign of violence. Even today, the proposed plea deal of 1-year probation is not just inadequate, it's dangerous. It sends a message that victims don't matter. Threats don't matter, and the system will always bend for convenience. It sends another loud and clear message to Scott that he got away with it again. While this case isn't resolved today, Scott faces new criminal charges also in Kanabec County. He was charged with 3 counts of disorderly conduct, including brawling or fighting from an incident on August 15th of 2024. That jury trial is scheduled for August 18th this year. This is not a man learning from his mistakes. This is a man who continues to reoffend, even while under court supervision and on bail. He is not just a repeat offender, as I stated. He is a current offender. The danger he poses, again, is not theoretical. It is real, active, and continues to escalate. According to the Bureau of Justice of Statistics, over 70% of state prisoners are rearrested within 5 years, and violent offenders are rearrested at even higher rates. When you factor in repeat domestic violence, strangulation, criminal threats, those odds continue to rise dramatically of reoffending. This court must recognize that probation in Lane's case is not a rehabilitative opportunity anymore. It is a revolving door that places victims and the communities that we all directly live in harm's way. Under Wisconsin Statutes Chapter 973, this court has the authority to depart upward from any sentencing recommendation when aggravating factors are present. Scott Lane is a habitual offender and has shown no remorse, no accountability, and no willingness to change. He's a danger to me, to my family, and to every member in this community. Probation is not justice. It is not safety. It is not accountability. If this plea is accepted, what message are we sending to victims? Is our safety negotiable? That the hours we've spent...
This moment right here is a gut punch not just to the victim, but to anyone who's ever trusted the system to protect them. A plea deal after decades of abuse and intimidation? The victim says it best, it sends a message that threats don't matter. So here's a tough question: is the system failing the people it's supposed to protect, or is it just overwhelmed?
Filing restraining orders, calling in the police, appearing in the court, collecting evidence, and reliving trauma in front of strangers, does that mean nothing? That abusers who stalk, assault, and terrorize can walk free with just a signature and a promise to behave for another year?